Good evening, Mr. Wilson.
Good evening, Deputy Chief Justice.
How are you?
I'm fine, thank you. I hope you're well also.
I am. Will you please tell us why you qualify for this job? Crisply.
I have an unusual, I would say, unique range of experience. I'm an academic. I'm an adjunct professor at WITS, recently published a book and got my PhD. I've also run a law office, a human rights law office, for 10 years, between 2010 and 2020. And I've also had 12 years as an advocate practicing at the Johannesburg Bar. And I think that range of experience has prepared me for the acting appointments that I started a little over 18 months ago. I've now acted, I'm in my 32nd week as an acting judge on the Gauteng High Courts. By the end of this term, I will have completed 40 weeks. And I've done the full range of work that's available to an acting judge on the High Courts, everything from criminal work to the full range of civil work, mercantile law, family law, opposed motions, unopposed motions. And so I feel ready. I think most importantly for me, this is a job I love. You get to go into court every day and two very intelligent people try to persuade you how to solve a problem about justice through the application of law. And then you go away and you think very hard about it and you get to write what you think the right answer is. I can't think of a job I've ever enjoyed more before. And I can't think that there's another job out there that I would enjoy more in future.
You founded SERI. You didn't mention that.
I founded, well, I said that I ran a law office. Perhaps I should have been a touch more specific. Yeah, I founded the Socio-Economic Rights Institute of South Africa together with Jackie Dugard in late 2009 and built that organization up into what I would suggest as one of the leading public interest law organizations in South Africa at the moment. I left in 2020, well, at the end of 2019, and my successor was Nomzamo Zondo, who is still running the organization.
Some of the commissioners are struggling to hear you. Will you bring your mic closer to your face, please?
I'm very sorry, that's not usually a problem people have, but I'll do my best to project my voice. Yes.
Yeah, that's better.
Thank you. And now the organization is run by Nomzamo Zondo, who worked with me for much of the time that I was director.
How have you found, well, in the statement you submitted, you say that pursuing research, advocacy, and constitutional litigation on behalf of poor and vulnerable communities is your passion. I'm paraphrasing. Now, yes. Half the work you do in the High Court is just black letter law, which someone like you might find a tad tedious and even dreary on occasion. You have not had that experience.
Tedious is the last word I would use to describe my 32 weeks as an acting judge. There is, in every case, in what seems to be sometimes the simplest unopposed motion, there's a social relationship. And that social relationship is mediated by law and the Constitution. And there's always something interesting to consider in any cluster of unopposed motions that you might have to do. And there are always considerations of social justice to apply your mind very carefully to. So I haven't found anything I do tedious at all. I even find things very interesting in case management court, which I did recently, because there you apply the practice directives to move civil trials forward, and the way that the process works has consequences one way or the other for how issues are matured for trial. So even that has its interest.
You've appeared regularly both in the Constitutional Court and the SCA.
Yes.
And ever as lead counsel?
Yes. I've appeared as lead counsel in the Supreme Court of Appeal 5 times, and as lead counsel in the Constitutional Court, I believe 13 times.
How many judgments have you been able to produce during your acting stints? I remember seeing a staggering number. What is it?
Well, I've
51 judgments.
that was with my application. I've now produced, as of the latest table I provided to the Judge President, 56 written judgments. The Judge President said I must include my extempore judgments. So if you include those, we get up to 70, but written judgments, 56.
Yeah. And some of them have been reported?
Yes, 3.
You've written a number of peer-reviewed academic articles and book chapters and 2 books.
Just one.
And what is the book on?
The title of the book is Human Rights and the Transformation of Property. It seeks to explain how the interaction of the right of access to adequate housing and the common law of property has driven social change in South Africa over the last 25 to 30 years. And it tracks the jurisprudence and suggests how changes in the jurisprudence might create spaces in which poor and vulnerable people can act more effectively for themselves to bring about the realization of their socio-economic rights and a more just distribution of land and housing in South Africa.
Yeah. Do you have any reserved judgments?
I have one reserved judgment. I reserved it this morning. But other than that,
it doesn't
none.
count then?
I'm sorry?
I'm saying that doesn't count. It doesn't
if
count.
it doesn't count, I have no reserved judgments.
Yes. Have you been able to have your judgments delivered promptly?
Yes, I generally between 2 and 3 weeks. I think at the outside, I took 6 weeks once, and my quickest, I handed down the day after, or maybe 2 days after.
Okay. You also have extensive research experience from your time at CALS.
Yes.
All right. Commissioners, do you have questions for Advocate Wilson? Aye. JP, I'm sorry. Well, I explained my predicament.
Thank you very much, TCJ. Good afternoon, Advocate Wilson.
Good afternoon, Judge President.
And is it correct to describe you as a social justice activist?
I think it would have been correct when I was the director of the Socio-Economic Rights Institute, and more precisely to describe me as a legal activist for social change. I certainly have opinions about the nature of constitutional law and how it can contribute to a more just society now, but my primary role now is as an independent advocate at the Johannesburg Bar and as an acting judge.
Now, your appearances in the Constitutional Court, in particular, you say 13,
I think,
where you appeared as lead counsel.
yes.
Right. Tells me that your area of specialization or expertise, or whatever you want to call it, is around the Constitution.
Yes, that's correct.
I see. So you live and breathe and dream the Constitution.
Yes.
I see. You argued the matter before a full court in which I presided.
I did.
Regarding search and seizure activities of the police.
Yes.
And you went on to win it in the Concord, am I correct?
Yes, I mean, we did quite well in front of the full bench, but we expanded the terms of the judgment and the order in the Constitutional Court.
Yeah. Now, in terms of your work in the division, I think the DCJ has covered that aspect. You've done work in the agent court. I think you had, the spreadsheet says you did a week.
Yes.
In the agent court. How many matters did you have, just for interest's sake?
I think in the end it would have been in excess of 15 or 20.
Yeah, because there's 2 judges in the Asian court
Yes.
every week, isn't it?
Yes.
And then that full court week you spent, did you write that full court judgment?
I did.
I see. And I think in opposed motions you've had 3 weeks.
Yes.
Yeah, that's where on average you'd get about, what, 10 matters
Yes.
for the week?
Yes.
Okay. And your stint in the criminal trials, how
Yes.
did that come about?
Well, by the time I'd finished my first term in civil court, I was beginning to think that this is something I might like to do permanently. And if I was going to make this application, I wanted to be able to say I could do the whole job. And so I asked you if it would be okay with you if I were allocated to criminal court duty, and you said yes.
Well, it's remarkable you made the request because it's unusual for such a request to come from someone who's had the practice you've had to ask to go to criminal trials. I will leave it at that, but to say, I wanted you to tell the commission how it came about.
Yes.
And you ended up dealing with one highly publicized matter
I
during
did.
your criminal stint.
Yes.
How did you find it? What was your experience in sitting in criminal trials?
In that particular criminal trial or generally?
No, generally.
I have, Judge President, some criminal defense experience. And very early on in my practice, I spent a lot of time in the Protea Magistrates' Courts defending trespass matters. And a little bit later on, I led the defense in a murder trial. And so criminal law is always something that I found quite interesting. But I wouldn't pretend to be the world's foremost expert on it. And so the initial response, once I realized I was going to sit in criminal court, was to tabulate in my head all the things I could get wrong, and to try my best to foresee them and ensure that I didn't get them wrong. And it was quite an extensive learning curve. And understanding not just the criminal law, the content of the criminal law and the content of criminal procedure, but how the various institutions involved in criminal trials work.
Yeah. But I'm sure you'd agree with me that the extent of your constitutional law knowledge stood you in good stead, because the judges who do criminal work tell me that to walk into any trial is like walking into a constitutional minefield. Yours
Yes.
as a judge is to avoid stepping on those mines.
Yes. I mean, the Constitution supplies the basic foundation of fairness to a criminal trial.
Yeah.
So if you are familiar with basic constitutional concepts, you are equipped to conduct the trial fairly. And in that sense, you're quite right, Judge President.
Yes. But the unfortunate part is this tends to prolong criminal trials because of all the ups and downs that are brought up before a judicial officer.
Yes. I mean, it need not. If you conduct a criminal trial with a degree of deftness and skill, you can foreshorten the delays, but they do happen.
Okay. I see you've written 2 judicial review judgments.
Yes.
The ESCOM Siemens matter.
Yes.
Yeah. But other than that, were you lucky enough to get any matter along the field you specialize in as counsel?
Well, the first 2 matters I heard in the Pretoria High Court in my first week were reviews of decisions of immigration officers. And those raised interesting questions of the applicability of PADRA as opposed to the principle of legality, and the factual bases on which immigration decisions could be made. So I found those quite interesting.
Okay. Thank you, DCJ. No further questions.
Thank you, JP. MEC Mamabolo.
Thank you very much. I must say that it wasn't my intention to ask you a question, Advocate, but there's a matter that interested me. in your responses to the Judge President. And when I look at your CV, that you are an expert in constitutional law, did I get it right? And maybe you can share with me your views about the principle of the rule of law, and not just to state it.
Yes.
Because when I listen to most people talking about the principle of rule of law, they just state it as it is. But I'd like to pick up your insights and understanding. If somebody were to say there are encroachments into the principle of law, crude subjectivity, personal beliefs and experiences of people, but also the South African context, where we come from, our history. Will you say that the still effectiveness of the principle, and if somebody was to raise those questions about erosion and, of course, encroachments into it, what will be your take on that?
I'd like to start, if I can, by stating what I understand the principle to be, but mindful of your request that I go a little bit further. I'll then go a little bit further.
Sorry, I didn't hear the first part.
I'm sorry. I'd like to start, if I can, by stating what I understand the principle to be, but then mindful of your request not to stop there. I'll go a little bit further. The rule of law is simply that we have a society that is governed by rules and not the personal preferences of those who have power. And it's actually derived from erosions into early European monarchical power. Personal, over a period of time, personal rule was replaced by rule by law. So the idea of the rule of law is that there's a series of rules we all agree to in advance, and they encase and limit what we can do in the pursuit of our political goals. And if you live in a constitutional state, the rule of law also defines what those goals are. The fundamental law is obviously the Constitution, and it doesn't just talk about how the game is played, it talks about where we should be going towards a more just society, where everybody can live with freedom, equality, and dignity. And so the rule of law can actually be an extremely rich concept that talks not only about the process of politics, but the values that we should be striving towards as well. It doesn't extinguish politics. It doesn't extinguish people expressing their personal opinions or beliefs or pursuing a particular political ideal. It just sets the terms on which those ideals should be pursued. So it's not, I don't think it's particularly should set the alarm bells ringing if we have a society where people pursue what might be termed by others their crude political preferences. As long as that is done constitutionally, through constitutional means, there's nothing wrong with that. The rule of law is there to police politics. It isn't there to replace it. I'm not sure I've answered your question.
Can I make a follow-up, Deputy Chief Justice?
Yes.
Yeah, I think you have covered good ground, but I still wanted to check your comment on the extent to which there's been the role of subjectivity in applying that principle. For example, I thought you'd also talk about judicial independence.
Yes.
And in our context, I thought you'll practically get into, is it effective in our country? There are people who are raising questions. So that's why I wanted to get your insights into whether you think there is or there's not creeping subjectivity that impacts the effectiveness of the principle applied in our country. So I wanted more your views, your insights as a scholar in the area, looking at your qualifications as well.
My experience of the last 12 years as a practitioner has been, on the whole, one of the enrichment of the rule of law, not its erosion. It's only through challenges, through meeting our challenges as a country head-on, by reference to legal rules, that we can enrich the rule of law and work out what it means for us. And so the criticisms that there may have been that the rule of law is being eroded by this or that particular form of political conduct may be part of the story, but I think it really misses the point. The question is, how do we respond to that conduct? How do we deal with what is considered to be abuses of power, corporate malfeasance, political malfeasance? And the answer to that question, more or less on every major issue in the last 12 years, has been, well, we ask what the Constitution says, and we try and guide ourselves with that document. The fact that people might disagree about what the Constitution requires is not a problem. It's the fact that it's constantly being referenced and it's constantly being applied that gives me a great deal of optimism about the rule of law and its enrichment in this country.
Prof. Marumachai?
Thank you very much, Deputy Chief Justice. A good evening, Judge.
Good evening, Commissioner.
I just have one question for you. And in relation to, I know that you are well versed in the Constitution, but I know that you are extremely well versed in one particular section of the Constitution where you have done extremely well, at least academically, Section 25.
Yes.
Of the Constitution. There are people who have referred to this section as the true dignity clause in the Constitution, and there is a debate going on in the country. On the one extreme of the debate is this section has sponsored the continued landlessness that people are actually experiencing. On the other hand, there are those who are saying, no, this section is actually fine. It's just that it's not implemented the way it should be implemented to ensure that people have access to their land through expropriation. I just want to understand, where do you stand in light of what I've just said, or if there is any other extreme that might be inherent in the debate? Perhaps maybe you can shed a light on that as well.
Well, I think that the Section 25 of the Constitution has preservative and reformist clauses. The effect of Section 25 is to freeze property holdings in South Africa as they were as at the date of its adoption. And there's no getting around the fact that that is at least partly a conservative effect. But that's not where Section 25 leaves things. Section 25(1) allows for non-arbitrary deprivations of property for the public good. In other words, deprivations of property or interferences with property that don't require the state to pay compensation. Then there are all the expropriation clauses. And then there are a whole series of clauses later on that seek to foster land, water, and related reform through the passage of legislation. Section 25 of the Constitution actually gives everybody in South Africa a right to tenure to the extent provided for in an Act of Parliament. I recently wrote an opinion on whether that has been given effect to. And so the question is that Section 25 is such a protean clause, it goes in so many different directions, that I would find it very difficult to characterize it either as an inherently conservative instrument or as an inherently revolutionary one. It embraces a wide range of potentials. And of course, it's easier to exploit its potential as a document or as an instrument that might be in favor of just leaving things the way they are. But I think the vast majority of people in this country have to accept and do accept and have a great deal of desire not to leave things the way they are, but to use the reformist parts of Section 25 to create a more just and equal society.
Thank you very much. Thank you very much.
JP Wakely.
Thank you, Deputy Chief Justice. Mr. Wilson, when I read your CV, I cannot help but get the feeling that you are very passionate about the constitutional aspects about housing and property law. And it's commendable that one is so passionate about these things because it does so much for so many. But my concern is that I think if you make yourself available for this position, aren't you in fact abandoning that passion? Because if you, I would think that a judgeship will be limiting in the role you can play in promoting these aspects of the law. Becoming a judge, an ordinary judge of the High Court. How many matters will you get that deal with constitutional issues? You're one of 76 judges in Gauteng. You know, when you act and it's enjoyable because you're doing those matters for a term. When it becomes a permanent, a full-time job, you're effectively changing your whole lifestyle or what you've done in the past to something very different. And my concern is, are you ready to abandon that passion and take on this new?
Well, first of all, I have to concede that when you become a judge, you leave certain things behind. By founding and developing SERI for 10 years and creating an institution that is self-perpetuating, I think that sort of puts paid to any question of abandonment. If you leave an institution behind that is capable of taking forward the projects that SERI does, then you can move on and pursue, to some extent, other interests. And certainly after 10 years at SERI, I decided that that's what I should do. I don't find my judicial work unengaging at all. I find the opportunity to layer different forms of law together with constitutional norms and values immensely satisfying. I have not had an uninteresting week in the High Court, precisely because there is such a rich intellectual challenge. There are no two cases that are alike, and the facts are always different. The law is always slightly different, and the way the Constitution applies, whether directly or indirectly, doesn't obviously apply in all cases, but more than you'd expect, certainly at the interpretive level. And all of that I find intellectually incredibly exciting, so that I simply don't see the abandonment of an intellectual commitment to the Constitution in moving on to the High Court. Of course, the role of a High Court judge is different to the role of a public interest lawyer, and my approach to the law and its administration will change and has changed when I've been doing judicial work. But that's a change I welcome and that excites me.
No, but do you accept, Mr. Wilson, that having done a stint or two at the High Court, that issues of constitutional law, are not issues which come up regularly? You won't find that in a divorce matter. You will seldom find it in a criminal matter, definitely not in the RAF matters. And these are the run-of-the-mill matters. My fear is that as a constitutional lawyer, trained, steamed, and have done so much work, you get into the High Court, would you not, within a 6-month period or a 1-year period, become despondent? That's my only fear. That's why I ask. Because as a judge president of the court, one does not want judges whose heart and soul is not in doing the job, but who think of, when am I going to get a constitutional law matter? Because you may not get it. As far as housing is concerned, I can't see you getting any at all. Because as soon as there is a matter, if you are allocated I would suspect that one of the parties will apply for your recusal, immediate recusal, because one looks at the amount of work you've put in, but each work has a slant towards certain aspect, direction. And that's my fear as well. So my fear, when I say my fear, I mean, is it something that you would be able to live with? Or would you abandon the court after a while? No.
I certainly
Well,
wouldn't.
I mean,
I certainly wouldn't abandon the court. If I can answer the question in two parts. The first is to address the proposition that you don't get, that constitutional issues don't arise in run-of-the-mill High Court work. They don't arise in every case, every week, but they arise more often than perhaps is being recognized. Rule 43 Court, for example, as the Constitutional Court has said, has critical aspects of gender equality about it. Power relationships in divorce proceedings, and how Rule 43 ought to affect those. I said in answer to the Judge President that constitutional law provides the value basis for fairness in criminal proceedings. So I think the Constitution can apply in multiple different ways, and I wouldn't just define a constitutional matter as a matter where you get to strike down or not strike down a statute. I know that isn't the suggestion, but there are lots and lots of different ways that the Constitution aids interpretation and conduct. So if I can set that point aside and just move directly to accept the premise for a moment that there won't be much constitutional work. I am a constitutional lawyer, but I'm not only a constitutional lawyer. I've done a range of other work, property law, labor law, quite a bit of landlord and tenant law, some criminal defense, as I said to the Judge President, and that interests me as well. The process of law interests me. The discipline of writing judgments and telling a story interests me. The whole range of the work interests me. And even if I were not to find another constitutional issue to come before me for the however many years I would serve on the High Court until retirement, I would still be interested in the work, and I would still be interested in the discipline of doing the work well. My career since becoming an acting judge has been one of massive variety. I just don't recognize a repetitive and boring strain to this job. I just haven't had it. And so I suppose in answer to your question, no, I won't become despondent. I'm sorry, Commissioner, I can't hear you.
I'm sorry. I see that you did say the whole range of work interests you, but that's not reflected in any of your articles, is it? I mean, there's only one aspect you deal with in article after article and after article. That's it's got to do with land, it's got to do with property. I have no problems with it.
Yes.
But thank you very much. Thanks. Thank you, Deputy Chief Justice.
Commissioner Ngoito.
Thank you, Deputy Chief Justice. Good evening, Advocate Wilson.
Good evening, Commissioner.
Very funny, strange to call you Advocate Wilson, but anyway. So, just the one proposition. I mean, I've certainly been becoming despondent about the constitutional project and about its very possibility, because it is undermined by inequality, by deepening levels of poverty, by crime and personal violence. And I think that sense of, is the constitutional project safe, has been a prevailing sense probably for the last, maybe since Marikana really. And Marikana represents this pinnacle of this crisis of constitutionalism. And one of the more hopeful constitutionalists that I know of is you. And your recent book, Human Rights and the Transformation of Property, is probably the most optimistic story of the constitutional success in the last 25 years. But its power, I think, lies in localization, in taking one topic and conducting an empirical analysis of that topic, and then looking back as to whether or not the project was worth all of the sacrifices, and then coming to an optimistic view of the constitutional project. So the reason I make this outline, I think it's in part to follow up on what Commissioner Wegley, Judge Wegley was talking about. There is a way of looking at the Constitution as a subset of law, but there is also another one of looking at it as foundational to the law.
Yes.
And I think your conception of the Constitution is the latter and not the former. And in that sense, what you live and what you breathe is in fact the constitutional system. Perhaps let's start there, and I'll come back with another question.
I'd certainly accept that characterization of my attitude to constitutional law, Commissioner.
Yes. And then there is also the optimism, right? But that is not I would say, an optimism of a young man. You are now much more refined. Perhaps you were pessimistic when you began, but you ended on the optimism side about the constitutional project and its viability. And in a sense, that is why I think your application is a very exciting project on its own. The taking of your own learnings and transporting them to the bench and trying to infuse virtually every legal question that comes in front of you with the, I would say, spirit of constitutionalism. Is that the way that you see your role? I mean, I think it's transformative in many respects. I hear your point about Section 25 potentially being preservative. We can debate that. I think it's only revolutionary. I think the preservation is the political compromise. But the text, which abandoned the right to property, which was in Section 23 of the interim constitution, abandoned that preservative element to it. Anyway, let me leave you to answer the basis of this optimism about the potential of the constitutional project.
Yes, I mean, your analysis of Section 25, Commissioner, I think makes you the optimist more than me. But I'll leave that there. Well, more of an optimist than me. As far as my own optimism goes and the way that I would seek to apply the Constitution as a judge, just on optimism generally, I just don't think we have any choice but to be optimistic. There's a Constitution. In relation to the MEC's question, I find optimism in the fact that people turn to law and legal concepts, politicians and ordinary people turn to law very often to describe what they want, and turn to the Constitution very often to describe their aspirations for a better society. That in itself is a cause for optimism. As a judge, I think that there are multiple ways in which the Constitution can be applied through my practice. And although it will be rarer for a constitutional value or a constitutional principle to be applied in a loss of future earnings case in a road accident fund matter, and I find contingency calculations fascinating. I know I'm probably in a minority of one when I say that, but there will be more opportunities to apply the constitutional principles. There will, of course, be cases, perhaps even the majority of cases, where the existing law is sufficient to solve the problem. And then what you do is you apply the existing law to the facts and you explain your reasoning. But I think that's where the fun begins. It isn't where it ends.
Yeah, and then the last point, I mean, there is another source, of course, to optimism, and that is your clients. It's remarkable that despite what they have gone through, the abandonment, the abuse, the beating by the police, they still remain optimistic in the value of the rule of law itself, and that they think that their salvation lies in lawyers and the legal institutions. And that is an inspiring story, which you actually tell beautifully in your book, that kept you at Seri for the 10 years that you were there. But how do we sustain this optimistic view of the Constitution? How do we sustain it when the World Bank tells us that we are the most unequal country in the world? How do we sustain it when we've just had the sort of July violence, and some intellectuals claim that in part it is influenced or fueled by the deepening levels of poverty? And how do we sustain it when we've seen the outcomes of the Zondo Commission report, and the political class has betrayed the constitutional vision? So how do we sustain this optimism that you describe in your book, that the first 25 years we end with a note of optimism, and then make sure that in the next 25 years we continue on the same trajectory that you describe? Where do you see us, and how should we do it?
Those are extremely demanding questions to answer, Commissioner. But I will, in a sense, it's going to be a repetition. What's optimistic about the State Capture Commission is that there was a State Capture Commission, and the things that it documented are open to public scrutiny and debate, and will aid in non-repetition. It's exactly the reason to be. I haven't just written about housing and property law. I've written about the Truth and Reconciliation Commission and education policy, but particularly in my work on the Truth and Reconciliation Commission. The thing to be optimistic about, as far as the TRC is concerned, is that there was a TRC, the truth was documented, and it will aid in non-repetition. And so, and again with the July riots, one of the major responses to the July riots was with the decision of the government to not to completely abandon something that looks like a nascent basic income grant, and to continue what was the COVID grant, and to continue the accretion of a welfare state in this country. And welfare states the world over are institutions of equality and institutions of justice. And it's not so much in the events themselves that I find the optimism, but it's in how we've been able to respond to them that I find the optimism. And on the two examples you've just given me, that's what I find, that's how I sustain the optimism.
I see the DCJ is given me a moment to sneak in another question,
I'm back.
but I won't.
I'm back in my chair. Commissioner Ngwaitobi, your turn is over. I've given you too much leeway as it is. Commissioner Nyambi?
No, it's thanks, DCJ. Evening, Advocate Wilson.
Good evening, Commissioner.
It's one question from my side. In your impressive CV, you have spent your entire career, you have devoted a lot of time representing the poor and the vulnerable. Probably you'll assist us, especially on the side of the Commission as politicians, because many times when we argue about this issue of access to justice, if maybe you can share what you view as the real impediment to these poor South Africans when it comes to access to justice.
I think that there are two principal impediments. The first is in fairly severe limitations that public interest law organizations try to address in the dissemination of legal literacy amongst poor and vulnerable populations. It's not just knowledge of the content of the law. When I talk about legal literacy, I don't just talk about knowledge of the content of the law. I talk about practical plans and workshops and discussions about how to access the rights that the law embodies. And sometimes to do that without fully fledged legal representation, without attorneys and advocates, but to make the Constitution and the law work as a layperson. paralegals in particular have a critical role to play in the expansion of legal literacy and in that sort of first line of practical application of law and the Constitution. And then there's the cost of legal services. The cost of legal services in South Africa far outstrips what can reasonably be afforded by most people. One of the ways to address the cost of legal services is to expand the scope and the resources given to the Legal Aid Board, which, especially in criminal court, in my experience, does a great deal of work with very few resources. But also, perhaps in the future, to look at regulating the cost of legal services. So those are the two principal barriers that come up again and again in my practice, and the beginnings of how one might begin to address them.
Thank you, Advocate Wilson.
Thank you,
DCJ.
Commissioner Dudu?
Thank you very much. DCJ, good evening. Advocate Wilson.
Good evening, Commissioner.
I have two questions for you. The first one relates to your dual citizenship.
Yes,
And you still hold dual citizenship.
I do.
Yes. I'm asking this question while aware that Section 174 of the Constitution indicates the eligibility to be a judge as far as the Concord judges are concerned, that you ought to be a South African, and it is open to other judges. It means even when you're from Taiwan or Pakistan, you are eligible to be a judge in South Africa. I'm quite aware of
Yes,
that.
yes.
Now my question is, in your good conscience, do you think that it is okay, notwithstanding that this is possible, this is lawful, in terms of the South African law and Constitution? Do you think in your good conscience, is it okay that you become a judge in South Africa whilst you hold dual citizenship? I'm asking you this question precisely because when you are a judge, you take an oath in terms of Schedule 2 of the Constitution, and that you shall be faithful to the Republic, you shall uphold and protect the Constitution. In your case, if I put it to you that you are not only faithful to the Republic of South Africa, but you are also faithful to King Charles III, what will you say if I say that to you?
Well, I first of all suggest that when I take the oath, there will be, if and when I take the oath, there will be nothing in my in the fact that I hold British citizenship that would stop me from executing that oath to its fullest. I suppose faith and the fact of citizenship are two different things. If one talks about faith, if one talks about my identity, I feel 100% South African to the exclusion of feeling British. I have married a South African man. I have a South African daughter. The entire core of my moral and professional being has been invested in the project of justice and dignity and equality in South Africa. I can't imagine being anywhere else or being invested in anything else. The fact of the matter is I wasn't born in South Africa, and that's why I have British citizenship. I'm not sure I want to swear fealty to King Charles III.
In fact, let me just follow up that. In fact, on the balance of evidence, with what I read about your profile,
Yes.
and that is to your advantage. There is no question about your commitment to
Yes.
to fight for socio-economic rights in
Yes.
this country. I don't doubt that
Yes.
with what I see, that commitment. But my question is, if you become a judge, will you renounce the citizenship of another country? I'm just asking.
I'm not.
And be faithful to what you believe in, where you take an oath to be faithful to that country and to uphold and protect its constitution.
I don't think it would be necessary to renounce British citizenship in order to be faithful to the South African Constitution. If I renounce British citizenship, I'm not sure that my sister and my brother would be particularly pleased with me, and it wouldn't be particularly easy to go and see them and go and see my family in the UK every so often. So that's the only practical reason why I wouldn't practically want to renounce British citizenship. But I don't see my British citizenship as an obstacle to my capacity to pursue my judicial oath. And for that reason, I don't see that it's necessary to renounce British citizenship. And I don't understand it to be a condition. You prefaced your question with an acceptance that it isn't a condition of becoming a judge either. So I suppose the one-line answer is that my birth citizenship absolutely doesn't preclude me pursuing and implementing my judicial oath to the fullest extent.
Okay, it's not for me to judge you or to say anything negative about you or to say I can't consider you because of that.
Yes.
Because that will be unlawful. All that I'm saying is that it is a bit odd, and it's not for this commission to resolve this matter.
Yes.
But it's just so odd that you can be elevated to judgeship when you hold dual citizenship. CJ, can I go to my second question quickly? Quickly.
Yeah.
Yes. Okay. My second question, and as it is, you're very strong proponent of socio-economic rights, the Bill of Rights, and all of that. In the year 2000, there was a Grootboom case that was resolved by the Concord. I'm sure you are familiar to it.
I am, yeah.
In terms of Section 25 of the Constitution. So it's a landmark case. In your respective view, do you think that authorities in South Africa across the board have done enough to ensure that everyone has got access to housing? And if that's not the case, what is it that we can do to enforce that judgment, to answer to that principal question as encapsulated in Section 25 of the Constitution?
Yes, thank you, Commissioner. The Grootboom decision was, of course, about emergency housing. And the way that Grootboom has changed the game in the right of access to adequate housing and in property law since it was handed down is to create a principle that, generally speaking, eviction shouldn't lead to homelessness. I think great strides have been made by a number of government entities across the country in implementing emergency housing programs and ensuring that emergency housing is secure and dignified for people who would otherwise be homeless. So that's the positive side of the balance sheet. Generally speaking, if one looks at the housing subsidy scheme and the construction of what used to be called RDP houses but are now called National Housing Subsidy houses, again, the number of housing subsidies that have been issued and the number of houses that have been built has been a success story. I think we have to acknowledge that. There have been difficulties with allocation. There have been difficulties with the location of RDP houses, and no form of social policy is problem-free. But there have been successes. I think the biggest single barrier to the implementation of the right of access to adequate housing is the non-availability of land, and that the state should be doing more than it probably is to ensure that land is released and made available, not only for emergency housing, but for secure tenure for poor and vulnerable people who face eviction on a daily basis.
Okay, thank you, DCJ.
Yeah, follow up.
Commissioner Matolotle, is it a follow-up?
Yeah,
Or you didn't ask me? So that's why I call somebody else.
yeah,
Go ahead.
okay. Yeah. It's on the first issue, Mr. Wilson, on the dual citizenship.
Yes.
I see here in terms of section 1741, with regards to the Concord, it is specific that you need to be a South African citizen.
Yes.
And I see your practice has mostly been on constitutional law and so forth.
Yes.
Are you not aspiring to one day be in the Concord? And don't you think this dual citizenship at that stage might raise some issues?
I wouldn't even begin to imagine that I'm going to end my judicial career anywhere other than the High Court at this stage. It's not for me to choose myself for promotion to the Supreme Court of Appeal or the Constitutional Court. It's going to take a good many years for me to amass the experience as a High Court judge that would be necessary to be considered for an acting appointment to the Supreme Court of Appeal or the Constitutional Court. Once I reach that bridge, I will cross it if there is an opportunity to do so. As I interpret Section 174 of the Constitution, there have been Constitutional Court judges, certainly Constitutional Court judges who weren't born in South Africa. I'm thinking particularly of Cato Regan, who was born not far from me, or not far from where I was born. She was born in Liverpool, I believe. I don't know whether she held dual citizenship at the time she was a Constitutional Court judge, but there have been Constitutional Court judges who weren't born in South Africa. And I would interpret Section 174 of the Constitution to permit a South African citizen to be a judge of that court, irrespective of what other citizenships they hold. But it's just not even on my radar at the moment, Commissioner. I'm applying to be a High Court judge, and in my foresight is a career as a High Court judge.
Oh, okay. Thank you, TCG.
Commissioner Matolotle,
Thank you,
do you have a
Deputy.
follow-up, Mr. Matthias? Okay, go ahead.
Just on this issue of dual citizenship.
Your mic is too far from
Sorry,
you, Commissioner.
just on this issue of dual citizenship. If you have a South African citizen, does it matter that you have another citizenship? Are you not a South African citizen?
I am a South African citizen.
Yeah, look, it's just that I don't follow this. That's why I want to clarify it to you, because all what is required, you must be a South African citizen, and you would be a South African citizen.
Yes, Commissioner.
Okay. Commissioner Matolotle,
Thank you, Deputy Chief Justice, and good afternoon, Advocate Wilson.
Good afternoon,
You
Commissioner.
know, I looked at your CV, I don't know what you call it, with admiration, and I'm asking myself, what's wrong with this picture? I looked at your age, and I'm asking myself, what went wrong in South Africa, where hardly women are seen, have what we have. South African black women who aspire to appear in constitutional court, like my friend here.
you're
my
speaking
learned
away
friend.
from the mic, Commissioner.
We are aspiring to appear in the constitutional court, and we can't get those opportunities. I'm asking myself, what's wrong? What's wrong with this picture? And since you are there, how do you assist us to have women, black women, or women in general, to appear in the Constitutional Court? Because after all, we are more than men in South Africa.
Yes. Well, of course, I've appeared with a great many women in the Constitutional Court. My most recent appearance, I was led by De La Hassim SC. She wasn't ultimately available to argue the matter, but she settled the heads of argument, and I worked on the team with her. I have led I've led a number of black and women juniors in the Constitutional Court and appeared with them. And it's, for me, it's part of what I tried to do when I set up SERI and developed it, was to create that space for black and women practitioners to be directly involved in some fairly complex and high-profile constitutional litigation. And all of the people I'm thinking of now who have been a part of SERI have risen to that challenge extraordinarily well and are some of the best lawyers I know. So I suppose the answer is institution building, creating an environment, as I've tried to do at SERI, which is diverse, which is not just diverse, but also broadly representative of the race and gender composition of South African society, and then treats everybody with dignity and equality, and treats everybody as if they are able to bring something important to the table in every constitutional matter. And I think we created that at SERI, and I think Nomzamo, my successor, Nomzamo Zondo, my successor, has continued that spirit. One of the letters written to the Commission was by a former candidate attorney at SERI. And when I read the letter, I was most pleased by his comment that my door was always open and I always wanted to know in every matter that he was involved in what his opinion was, even though he was a junior candidate attorney on the matter. And he could see that his opinion and his view influenced my thinking. And it's the creation of that sort of environment where people will give their opinions and know that their opinions will be valued. That's what I've tried to do when I've built SERI as an institution, and I think that's the way to ensure a diverse and a dignified and an equal legal profession.
Have you finished? She has to finish first.
A follow-up or not?
Yes.
I understand we need to create an environment, but I'm asking you, what other extraordinary measures we can take to have those women appearing in the Constitutional Court?
If the question is how do we ensure that black and women advocates succeed in their career to the point where they would be leading interventions in the Constitutional Court, there are a number of things that need to be done in order to reduce barriers of access to the legal profession. Probably so many that we'd be sitting well into the night if I listed them all. But the principal one for me is that we have to start paying pupils as of right. PABASA has started to do it. The Legal Practice Council has introduced the CETA grant. But it just seems to me that the biggest barrier to access to the advocates profession in this country is the failure to pay pupils, because we know that economic hardship falls disproportionately on black and women entrants to the profession. And what we're asking those black and women entrants to the profession to do is work for a year without any remuneration at all, and then take on what we're sometimes doing is asking them to work without any remuneration at all, and then take on the onerous obligations of economic obligations of practice from day one. Often while trying to understand and address briefing patterns which often put black and women practitioners at the back of the queue. And I think that we're just setting ourselves up for failure if we can't at least make sure, as a fairly well-remunerated profession, that pupils are paid as of right.
Okay, thank you, Deputy.
Follow up Commissioner Steinberg?
Good evening, Mr. Wilson.
Good evening, Commissioner.
Just a comment on the last point that was raised. You and I have been in the same group for over a decade, and
Yes.
you are very well known as an advocate who actively incorporates black and female advocates as juniors and trains with great dedication. And you can only be commended for that.
Thank you, Commissioner.
If I may, DCJ, to add on this point, you know, when Seri first briefed me in 2013, and I was still a junior, you insisted that I can only accept the brief if I had a black woman.
Yes, carry on.
Can I just follow up from
Yes.
the comment? I'm not saying Advocate Wilson is not. I'm saying, how do we get there and have 10 of them to get there, not 1 or 2?
Yes, that's how I understood the question.
Commissioner Pillay?
Thank you, DCJ. Good evening, Advocate Wilson.
Good evening, Commissioner.
I do have one concern about your application.
Yes.
And I'll tell you what it is. I've looked at your proportion of litigation work, and it struck me that you don't have any experience in commercial law. Now, obviously, you'll know that the division is basically the busiest commercial division in the country. And ordinarily, for reasons you've mentioned around briefing patterns and the structural factors that work against black women, one would overlook that if you were dealing with a black woman candidate. But in your instance, perhaps you can just help us as to what we do with that. You know, you
Yes.
do lack commercial experience,
Yes.
and there aren't any factors which would mitigate that
Yes.
in your case.
Well, I first want to discuss what counts as commercial experience. Commercial arbitrations, competition law, black letter contract law, I would accept the proposition that I have very little experience in, no experience in competition law or commercial arbitrations, and relatively, actually very little experience in black letter contract law. I wouldn't accept that because of that I don't have experience in commercial law. A great deal of my practice for 2 or 3 years was all about banking law. Banking law from the perspective of debtors rather than the banks. But I still had to know what the National Credit Act was. I still had to, I appeared as leading counsel in both the Constitutional Court cases that dealt with the meaning of Section 129 of the National Credit Act. The housing and eviction law raise fundamental commercial and contractual issues. I've appeared in the Rental Housing Tribunal. I've litigated rental housing issues all the way up to the Constitutional Court. Again, fundamental issues of landlord and tenant arising there. I would suggest that I've had exposure in my practice to commercial issues, although I would accept the proposition that what people would ordinarily expect to label as commercial law is a weak point in my practice. I'd point out that I have written judgments on commercial matters. The one that's leaping to mind at the moment is a judgment in urgent court about intellectual property that I had to write and that I've included in my application. And I have shown the ability to get at the core issues in commercial matters that come before me, and to evaluate those issues and make the right decision, or make a decision that is defensible, but come to a well-reasoned decision on that matter. There's another trial I presided over about insolvency. In fact, I've done 2 insolvency matters, but there's a trial I presided over about the impact of insolvency on damages to be claimed in terms of breach of a lease or following on breach of a lease. And again, that required me to research and to apply commercial, what you would call ordinary black letter commercial law, very, very carefully. There was also, obviously, I've done opposed sequestration and liquidation applications. I've most recently been involved in my practice in an application to liquidate a housing association. Again, something that requires knowledge of liquidations, which are perhaps as commercial as they come. With those various caveats, I would accept a part of the proposition that you've put to me, Commissioner, but I'd want to qualify it in the ways that I have done. And so the question is, what do you do with it? Well, I would ask you to accept that you will, if you recommend me for appointment, you will be recommending a judge, a candidate whose background may well be in constitutional administrative law, but has been able to show that he can understand and apply commercial law in its entirety.
Thank you, DCJ.
Any questions from the virtual platform?
I have no questions. Thank you, Deputy Chief Justice.
Commissioner?
No question. No question, DCJ.
Thank you. Well, we've reached the end of your interview, Mr. Wilson.
Thank you, Deputy Chief Justice.
You're excused.
Thank you very much, and thank you for the time.